Good afternoon, everyone, and thank you for the very warm introduction, Rain. It's my absolute pleasure and honor to be able to address such an esteemed delegation today. So, good afternoon. We begin this keynote with a quote by the eminent Dean Roscoe Pound. "The law must be stable, and yet it cannot stand still." Well, if we're to rephrase it, it must be stable, but it must also meet the changing demands of society. The world we live in now in 2022 is drastically different from what it was 10 years ago. 2010 is more than a decade ago. Back then, we were just being introduced to the iPad. Instagram was being launched for the very first time. Android was just starting out, and BlackBerry was still a thing. 4G was slow, expensive, and unreliable. The average internet speed was 0.9 Mbps. Grab wouldn't even come into existence until 2 years later. It's even more unrecognizable from the life we knew in the 20th century. Does anyone remember ISP Bonanza and the dial-up tone? In the post-PC era, we now hail transportation through our phones, shop through our phones, bank on our phones, and so much more. There's an e-equivalent to everything nowadays. E-wallets, e-docs, e-shopping, e-whatever. It's the digital shift. But most importantly and more relevantly, we now work, teach, and attend class from home. The pandemic has accelerated technological adaptation at an unprecedented rate. Now that we're in the new normal, there are things that we ought to keep. There are things that are going to stay. But there are things that we ought to say goodbye to. Technology, for better or for worse, has changed the way we do things, COVID or no COVID. And it's rapidly changing still, such that we ought to adapt lest we be left behind and become irrelevant in the process. But before we delve into those in detail, I'd like to provide an outline for today's keynote. First, I provide a framework that allows us to categorize various emerging technologies and how they affect the legal landscape into 3 neat categories. Second, we examine each of these technologies bit by bit, according to the framework provided, and how we can change and adapt because of them. Lastly, we wrap things up by trying to answer the question posed by the title of this keynote. How do we future-proof law schools and provide stability in a sea of change? So, thank you all again for being here. Let's begin. The first category pertains to technologies that change pedagogies and learning methods. Zoom, Google Meet, learning management systems, Exemplify, Edpuzzle, Noodle Factory. Fairly self-explanatory. The second category pertains to technologies that change the conduct of legal practice as we know it. Digitalization and modernization of court and administrative agency processes, e-notaries. There are even artificial intelligence robots that are available to predict the outcome of a particular case when fed with relevant laws and jurisprudence. I'll not delve into this particular category in detail as it's easy to grasp, but needless to say, future lawyers must be equipped with the requisite knowledge to be able to handle these technologies. They should be able to keep up. COVID has already jump-started this because we have e-hearings, e-filings. So we're just continuing that even further, and we should empower not only our students, but also current lawyers in being able to adapt to these various changes. The third category, and perhaps the most important, pertains to technologies that necessitate changes in content. These are new subjects that need to be taught, or if they're current subjects, we need to put more premium on to reflect current social realities. But before we tackle these categories one by one, it's perhaps fitting to discuss the main challenges we face in our pursuit of digitalization. To loosely quote a speaker at the recent EduTech conference, the digital shift was traumatic, to say the least. Our research at LEAP shows that there are glaring issues in relation to equity and access to technology. The data we've gathered shows that there are a good number of students whose currently owned laptops don't meet the minimum required specs for the bar exams. So with that in mind, they'll have to either borrow or buy new ones. But at the same time, a significant number of students have also stated that they have no financial means to do so. This is on top of their sentiment or their feelings that internet pricing is also not affordable. Let's also consider the bar exam fee, which is now at 10,000 pesos. I say it's more than double, but someone has pointed it out that it's almost actually triple than the previous amount of 3,750. So, from a structural perspective, we also have perennial issues that have not yet been solved. Poverty, illiteracy, corruption, they're still very much present. These are analog problems. But the fact that we're adding digital problems exacerbates these problems even further. So now, as we discuss these three categories driving change, let's keep these challenges in mind. On to the first category, whereas traditional teaching methods consist of the professor either conducting a lecture or, especially in law school, using the Socratic method, technology allows for new ways of teaching and learning. We're not saying that traditional methods don't work. Rather, we need to be flexible enough to add new tools in our toolbox. Not all students or classes learn the same way. And not all content are appropriate for lecture or the Socratic method. We need to be able to identify the proper tool to match the students and the content. Our COVID experience has shown that remote learning can be done. But now that face-to-face classes are again possible, do we go back to what once was? Or do we retain best practices and see what works best moving forward? Dean Shuaid from the University of Cebu has stated that hybrid is here to stay. His personal experience has convinced him that hybrid setup can make learning and teaching more effective. We know about Zoom and Google Classroom. But in relation to the commitment to a hybrid setup, I'd like to highlight two special technologies that are making their introduction this year in 2022. Class in X and Noodle Factory Artificial Intelligence. Class in X is a combo solution that merges online and offline experiences, such that it augments face-to-face classes, but at the same time, it simultaneously allows for remote participation by those who are unable to do so, either the student or the professor. So that makes learning happen anytime. Noodle Factory, on the other hand, is much more powerful. I'd like everyone to meet Winnie and Walter. These are artificial intelligence teaching assistants. For professors, they're able to help craft questions. Not in lieu of the professors crafting questions, but help craft questions. But with these questions in mind, when fed with particular data, these AIs can also check exams, attendance, and more. So with this in mind, our professors are now able to focus on teaching rather than being saddled with non-teaching tasks. For students, Walter is able to give personalized feedback and tutoring adapted to individual needs. This is a particular sentiment that all students across the entire country have stated. They would want personalized feedback from their professors. And this research has been done ever since 2018 and still holds true today. But now, as teaching methods themselves, we must address the elephant in the room, the Socratic method. We don't have to eliminate the Socratic method completely, but there is a need for, a more rounded approach. When I was reviewing for the bar, I was given pre-recorded video lectures. And it was so effective, I thought that if I had these as a student, my performance would have been much more effective. So the question is, why are we reserving these for bar examinees when we can share them from first year to fourth year? Teaching methods are not mutually exclusive. Both lecture and the Socratic method can coexist. They complement each other to make learning that much more effective. Let's add a third element still. Some subjects are best taught through experience. CLEP is proof of that. And to reiterate the point shown in EduTech, students remember 10% of what they read, 10% of what they hear, but 90% of what they do. This shows the great effectiveness of experiential learning. So now that we've covered teaching and learning, how do we effectively assess students given the technology available today? We look into the procedural and the substantive. The procedural first. Our research at LEAP shows that typewritten exams are the way to go. An overwhelming 98.29% prefer digitized exams. The remaining 1.71% pat themselves on the back for commendable penmanship. And, you know, this overwhelming sentiment is because digitized exams are faster to answer, easier to change answers, easier to skip questions, easier to review. But for those evaluating the exams, it's also easier to read. This is not just true for the bar exams, but assessments in general. Let's go one step further. Examplify's full feature set can be used. Examplify has a feature where it can utilize a computer's webcam to determine and flag instances of possible cheating. This allows for more test taking at home while preserving academic integrity. No more need to handwrite exams and send via LBC. And for some professors, no more need to have 3 devices at the same time just to prevent cheating. Using technology properly makes our lives more convenient. Most important of all, perhaps, though, is the change in mindset. In an age of quick searches and fast answers because of Google, content is everywhere. And because content is easily accessible, questions now shift from what is to how it is applied. There's now a paradigm shift, perhaps, in favor of open book exams. It's a sentiment shared by law deans, again, in our debriefing session at the EduTech conference. In the law school context, memorizing is somewhat outdated per se. That's not to say it's unimportant. Quite the contrary, it's very important. But in asking questions that require higher order thinking skills, application, memorization is considered a given. It's a prerequisite, such that even if it's an open book exam, if the student hasn't made the requisite memorization, then the student would still find it impossible to answer the question. But at the same time, if we're able to design questions this way, we're also able to test critical thinking, analysis, application, synthesis, and evaluation. Skills in the ascending order of higher thinking. This idea isn't novel. We already have a proof of concept in 2011 from Justice Abad's bar exams. The drafting of a trial memorandum or a decision and legal opinion, questions designed precisely to test higher order thinking required for practice. Now we shift our focus to the substance, the meat of it. This brings us to the third and final category, technologies that drive changes in substance to reflect current social realities and practice area demands. In 2020, the world generated 2.5 quintillion bytes of data in a single day. That's a lot of data. And that has implications in how we think, act, and regulate ourselves as a society. But it also has corollary legal implications. Intellectual property, data privacy, civil law, criminal law, banking, finance, so much more. It pretty much covers all law subjects at this point. So the question is, are our future lawyers able to fully appreciate and apply these laws in relation to the world around them? What about current lawyers who are struggling to comprehend technology and the latest laws surrounding them? Will current MCLE efforts be enough? So hypothetically, let's discuss certain subjects in particularity. How can we expect these same students and lawyers to prosecute and defend cases of estafa when committed through platforms like GCash? Literature shows that there has been a 37.28% increase in online scams, 57% increase in suspicious transactions from 2019 to 2020. Phishing, smishing, vishing, and other online fraud schemes naturally increase as transactions shift online. And that has only accelerated because of the pandemic. Most of these instances even concern unverified wallets, which is a huge part of our population because of our current socioeconomic status. And these are inherently high risk. What about those scam texts that we've been getting very, very often lately? That concerns the data privacy at the very least. In terms of civil law, how can our succession lawyers successfully conduct estate planning if they don't understand the concept of digital assets, cryptocurrency, and non-fungible tokens? There's an artist named Pap, and he created a non-fungible token called the Merge. Recently, it sold for $91.8 million. Imagine a digital file, something stored on the computer, selling for $91.8 million, just because it's authenticated. Hypothetically, in terms of succession, if the original owner passes away, but someone else were to copy-paste the file, what property rights would govern which specific copies? The NFT itself, the file with inherent monetary value, would be owned by the decedent's heirs. But the person who owns the duplicate, the one who pressed Control-C, Control-V, would pass on the files without inherent economic value, the duplicates in short. In terms of intellectual property, how can we expect these same students to handle cases on copyright infringement of computer code? Without copyright protection of computer code, we wouldn't have Face ID on the iPhone, cloud storage like Google Drive, and so much more. Computer code may be seen as something mechanical, but it's actually a product of human originality. And this is especially relevant because app development and coding has been one of the fastest growing occupations in recent years. It continues to do so. Now, let's shift gears for a bit from being high-tech to being more regional in a sense. Comparative law, too, is becoming increasingly important. In an age of internationalization, cross-border practice will eventually become the norm. This is where the initiatives of LEAP and the LEB on the Philippine Qualifications Framework comes in. By way of example, at Seoul National University, not only are law students taught municipal and international law for South Korea, but they are also taught constitutional law, mercantile, administrative, judicial, and private laws of other jurisdictions. The United States, Germany, France, Japan in particular. This gives them the foundation to practice not only in South Korea, but in other jurisdictions as well. Where does technology come in? It takes center stage because law schools are no longer confined to professors who conduct classes physically. The pandemic has shown us that remote learning and hybrid setup can work, given proper capacity building. Now we can have professors from Metro Manila teach in the provinces, and professors from the provinces teach in Metro Manila. Let's expand even further. We can have professors from abroad teach in the Philippines, and our esteemed professors from the Philippines teach abroad. With the advent of the ASEAN Economic Community, Filipino lawyers are in a prime opportunity to flex their wings both at home and abroad. The intended free flow of labor by the ASEAN Economic Community could now include legal professionals, if enabled by the Philippine Qualifications Framework. All these provide impetus for changes in curriculum. While some subjects, like constitutional law, civil law, criminal law, are perennially important, we can perhaps streamline, consolidate, and perhaps even relegate certain subjects to electives to make way for a host of new core subjects. Data privacy, intellectual property, fintech, biotechnology, competition law, environmental law, human rights, amongst other things. These are all important subjects in today's world. These are subjects that define and reflect our current realities, much like how Latin, apologetics, admiralty, and military science in the United States government defined the 1930s up to the 1970s. These were subjects featured in the Ateneo and the University of the Philippines way back when. Remember, these were the pre-war and the war years. But I'd like to give a special focus to biotech and human rights. Not because of the pandemic, but because of controversial and unregulated technologies that are already here in 2022. As of 2 days ago, December 5th, the lower house approved at third reading the Virology and Vaccine Institute. We need competent lawyers, legislators who can effectively make legal frameworks for these technologies. I'd like to single out one technology for biotech in particular, CRISPR-Cas9. It allows for gene editing to add, remove, alter an organism's DNA. While the technology started as a means to prevent diseases and increase crop yields, it now extends to editing human DNA. This has implications on legal doctrines relating to DNA testing, proof of filiation, forensics, and more. The amount of possibilities are endless. Does anyone remember the film Gattaca from 1997? That is very, very real. Let's not even get started on human cloning. Remember Dolly, the sheep from the 90s? In the realm of human rights, we have emerging technologies such as artificial intelligence and facial recognition. There are a host of constitutional implications, police power being the most concerning. Do we want to become like China, where mass surveillance is the norm? But we've done research, and the technology is still not ripe and reliable enough for en masse deployment. Coupled with the lack of current legal framework, deploying facial recognition is prone to abuse, especially by law enforcement. These are all very, very difficult questions. Questions that we must face in determining the substance of what we teach in law schools. What are considered core subjects? What are considered elective? This is where the importance of academic freedom comes in. No one-size-fits-all policy for all law schools. But it must be pointed out that each law school is in a unique position to respond to the unique needs of the geographic community in which it is situated in. By way of example, mining is a huge issue in Baguio. By way of example, then, law schools in Baguio would stand to benefit from increased focus in environmental law. In Mindanao, children in conflict with the law and women's rights become the focus of legal studies. Again, no one size fits all. So the question now is, how do we find stability in a sea of technological change? It's a question whose answer is a continuously developing one because the curriculum is a living document. We can't have an immediate answer right away, but we can have a starting point. We find and stick to what is constant no matter what. And that constant factor is that which makes us human. No matter the changes in hardware, no matter the changes in software, no matter the changes in technology around us, Peopleware stays constant. That's you, me, and all of our fellow human beings. We stay constant no matter what. So what skills must lawyers possess that are considered timeless? What are timeless skills that never go out of fashion? We want creative, multidisciplinary, ethical, critical problem solvers, and lifelong learners. These soft skills can never be replaced by technology. The human brain is a fluid supercomputer. It's the most powerful computer out there. Unlike an artificial intelligence which is programmed according to a set of rules, making AIs resistant to change, the human brain can continuously learn and adapt. We've been doing so for thousands of years. In fostering multidisciplinary thinking and creativity, we want our students to explore the world as much as they can. They shouldn't be spending their time locked away in their rooms, preparing for class, reading materials in a vacuum. Instead, they should be given opportunities to explore what they learn in the real world. We need input. We need food to feed our imagination. Students shouldn't also be afraid in voicing and raising independent and divergent thoughts. In law school, discussions shouldn't be confined to what the Supreme Court says. After all, some prevailing case laws were once dissenting opinions. In fostering lifelong learning, we need to show the joys of learning in and of itself. That learning is not just confined to schools and assessments. That learning can happen anywhere and anytime. In an age where remote learning is possible, this underscores the importance of physical spaces. Schools, actual campuses, physical spaces are spaces for, are areas for socialization, where people make friends and learn from each other, because human interaction breeds learning. We give emphasis on instilling the legal mindset so that future lawyers have a framework. They're properly equipped with dealing new and novel laws in situations, whatever they may be. So it's not the what of learning, it's the how of learning. The late, great Professor Ruben Balane is a perfect example of all of these. He learned for the sake of learning. His effortless creativity came from the fact that he was incredibly well-read and well-traveled. His mastery of multiple languages and linguistics allowed him to make connections between seemingly disparate things and understand the world in a multidisciplinary manner. He wasn't afraid to go against the grain either. So, to recap this entire keynote, we summarize it into 3 main ideas. Legal education is not insulated. It's a product of factors that surround it. We're continuously being affected by everything around us, but most especially technology. So we need to recalibrate our content and our pedagogies. And lastly, Peopleware stays constant. Creativity, lifelong learning, multidisciplinary and divergent thinking, synthesis, and ethics. These are skills that are inherently human that can never be replicated by artificial intelligence or any form of technology. As a parting gift to all of you, I'd like to leave you with a short clip from one of my favorite K-dramas, the critically acclaimed Strange Attorney Woo. Strange is the literal translation of the Korean title, but the English title, Extraordinary Attorney Woo, seems much more appropriate. Throughout the series, it's evident that she's a cut above her fellow lawyers, much to the envy of a particular junior associate and to the displeasure of a certain senior partner. This short clip shows that while she seems strange at first, she's actually very extraordinary because she's creative, she can think divergently, and she's inherently multidisciplinary. So with that, good afternoon again, everyone, and thank you for your time. Enjoy.